Hi, this is the Business Guy. I'm the CEO of Asset Protection Planners and Lawyers Limited, the nation's largest asset protection firm. And today we're going to talk about the Cook Islands statute of limitations on fraudulent transfer. With the Cook Islands Trust, there's a 1 to 2 year statute of limitations on fraudulent conveyance or fraudulent transfer. That is 1 year from the time the settlor registers and funds the trust, or 2 years from the cause of action or the reason why the plaintiff filed the lawsuit. Cook Islands courts will refuse to hear the case after that period of time. Now, I've personally been setting up trusts in the Cook Islands since 1996 and have established more Cook Islands trust than anyone in the world. And to be clear, the statute of limitations does not mean that the assets are unprotected for 1 to 2 years. The Cook Islands Trust protects assets immediately. It simply means that the courts won't hear the case challenging the transfer of assets into the trust after that time. But there is something that you should know that is far more important than this, and I'm going to tell you what you should never ever say when you have a Cook Islands Trust if you want it to protect you from the most determined creditor. And believe me, you won't want to miss this. But first, you don't want to miss the latest asset protection tips when new videos come out, so you can click the subscribe button and notification bell to keep up to date. And if you appreciate this insight, please click the like button below so YouTube promotes this video. Thank you so much. Fraudulent transfer. Let's back up a bit so we're all talking about the same thing. Fraudulent transfer, also known as fraudulent conveyance, is typically a civil issue and not a criminal one. It particularly arises when a debtor is insolvent. That is, the debtor does not have enough assets to cover his or her debts. Creditors or bankruptcy trustees are usually the ones who file these actions against the debtors. Making oneself insolvent typically involves a debtor who donates his or her assets. They usually transfer them to an insider, such as a family member, and that leaves him or her with nothing to pay debts. In a successful suit, the courts entitle the plaintiff to recover the property that the debtor transferred. Alternatively, they may simply receive its value from the person who has received the gift of the debtor's assets. Furthermore, this often involves a lawsuit against the recipient of the transfer. So legal advisors strongly discourage transferring assets to family members for asset protection. Simply put, it doesn't work. Plus, it will likely entangle the family member in your legal battle. So let's talk about the Cook Islands Trust Fraudulent Conveyance Statute. So what do the statutes say? Now bear with me because naturally the laws are written in legalese. So we'll first wildly entertain you with the statutes, and then we'll interpret them into plain English. Specifically, the Cook Islands International Trust Act of 1984, as amended, says the following. Section 13b(3), an international trust settled or established, and a disposition to such trust shall for all purposes be deemed not to have been so settled or established, or the property disposed of with the intent to defraud a creditor, A, if settled, established, or the disposition takes place after the expiration of 2 years from the date that creditor's cause of action accrued, or B, where settled, established, or the disposition takes place before the expiration of 2 years from the date of the creditor's cause of action accrued, that creditor fails to commence in a court of competent jurisdiction proceedings in respect that creditor's cause of action before the expiration of 1 year from the date such settlement, establishment, or disposition took place. So what the heck does that mean? Let's talk about what 13b of the International Trust Act means, and we'll explain it in the context of the remainder of the statutes. Number one, it does not mean that the assets are unprotected for 1 to 2 years. As we said, the Cook Islands Trust protects assets immediately. Number two, it means that inside of this time frame, the creditor can file a fraudulent conveyance action in the Cook Islands. However, the creditor is highly unlikely to win. Number three, so it means that if a creditor wants to file a fraudulent conveyance lawsuit, according to other parts of the Act, they need to file it in the Cook Islands within 1 to 2 years. Number four, that is, once the statute of limitations runs out, the Cook Islands courts will dismiss any lawsuits claiming fraudulent transfer of assets. Number five, once a lawsuit runs its course in the defendant's home jurisdiction, the statute of limitations clock will likely have run out. Therefore, it will bar the suit in the Cook Islands. Number six, and it gets even better, suppose, and this is highly unlikely, your opponent files the lawsuit in the Cook Islands before the statute of limitations. The plaintiff or the creditor, the one suing you, would have to prove the following. A, the reason you established the trust was to fraudulently transfer assets away from that particular creditor. That is, they transferred assets not just away from any creditor, but from the creditor filing the lawsuit. B, most notably, the plaintiff will need to prove his or her case beyond a reasonable doubt. The burden of proof in most civil lawsuits is by a preponderance of the evidence, that is 51% to 49%. However, in this instance, it requires 95 to 97% proof of the facts, and this is nearly impossible to do in actual practice with respect to asset protection trusts. That is because the defendant can simply let the other side know they established the trust for some other reason, which we'll discuss in a moment. Number 7, moreover, the Cook Islands recognizes immigrant trusts. For example, let's say a person has an existing revocable living trust that holds assets. We can amend that trust, and I've done that many times, and turn it into a Cook Islands trust. Therefore, it will be the same trust, but with different wording. Thus, the assets the trust held therein for the previous 1 to 2 years will have already passed the statute of limitations test. Thus, the amended trust instantly protects assets from a fraudulent transfer challenge in Cook Islands courts. Now, here's the big warning as promised. Never say this. Since you want to avoid the appearance of fraudulent conveyance, especially before the requisite time has elapsed, here is what to never say. Quote, I set up this trust to protect my assets from you, Mr. Judgment Creditor. Don't say that. It is in your best interest that such a statement, or one similar to it, never show up in a deposition or court transcript. If it does, and your opponent hurries up and files the lawsuit in the Cook Islands before the deadline, it could come back to haunt you. There are many other reasons for setting up Cook Islands trusts that appear more acceptable in the eyes of the court. So here are the reasons, other than asset protection, for setting one up. Reasons for setting up a Cook Islands trust. Now, here are some reasons for setting up a Cook Islands trust other than asset protection. Number 1, diversify. The trust was established to diversify investments internationally. Number 2, legacy. To create a legacy for many generations. That is, you can honestly say that you established the trust to place funds in a jurisdiction that allows the trust to last indefinitely. Many jurisdictions, such as those in the US, Canada, Australia, UK, for example, force trust dissolution, for example, 21 years after the death of the last named beneficiary who was alive at the time the trust was created. Number 3, trustworthiness. Transparency International has listed New Zealand as the most trusted jurisdiction in the world for many years. Now, Cook Islands is part of New Zealand. Number 4, history. Cook Islands Trust have a long and trusted track record. The International Trust Act was enacted in 1984. Number 5, bankruptcy protection. The trust remains valid when the settlor or beneficiaries had filed for bankruptcy. Now, there are a plethora of other reasons one can offer for setting up a Cook Islands trust other than asset protection. Cook Islands fraudulent dispositions. Prior to the fraudulent disposition revision for trusts, the Cook Islands and most other British colonized financial centers fell under the Statute of Elizabeth, which did not offer strong protection against creditor claims. The new law greatly increased asset protection, and it did so by requiring the creditor to prove that the trust was created solely with the intent to defraud that specific creditor. When the creditor does not prove intent to escape a debt from the creditor, the trust assets are not subject to the creditor's claim. Please like, subscribe, and share this video. This is The Business Guy.